So today we have Ryan Bickmore, who is an associate at Hogan Lovells, where his practice focuses on environmental and litigation matters. While in law school, Ryan interned at the DOJ's Environment and Natural Resources Division, and also at the U.S. District Court for the District of Columbia. He also clerked for the Honorable Alan Kay at the U.S. District Court for the District of Hawaii. We're also joined today by Madeline Fleisher, who is also associate in the environmental practice of Hogan Lovells. Prior to joining Hogan, not too long ago, I think, she was a trial attorney in the environmental defense section of the Department of Justice, where she handled litigation in the federal district courts and the courts of appeal under statutes including, not limited to, the Clean Air Act. So with that, I will turn it over to Ryan.
All right, thank you. Thank you everyone for coming out today. Today we're going to talk a little bit about the Clean Air Act and climate change. The Clean Air Act is a massive statute with a number of programs, so we're not going to be able to get through all of the different programs, but we're going to sort of hit the highlights. First, we're going to talk about what is air pollution, where does it come from, and why do we care about it. Then we'll talk a little bit about how you go about regulating those pollutants, air quality planning, new source review, and then we're going to talk about climate change, which if I had to guess is probably why most of you are here today, and for good reason. And then after we go through all that, Madeline is going to talk about a case that was recently argued before the DC Circuit, which sort of blends all of those concepts together. Air quality planning, interaction between EPA and the states, and also greenhouse gas regulation. She actually argued that case before the DC Circuit, so I'm sure she can answer any questions that you possibly have for her. This is just the past month that this argument was held. And also, as I go through my lecture, if you have any questions, please go ahead and ask them either in person or on the phone. This works better sort of as a dialogue than as a lecture. So before we dive in to talk about the first of the criteria of pollutants, to give you some background as to what led to the modern Clean Air Act. In the 1950s, there were a lot of air quality related deaths. In London in 1952, there was 4,000 people that died due to air pollution related problems, and then in New York in 1953, about 250 people died from air pollution related concerns, and they started calling it killer smog. And so certainly it was on the national conscience, and Congress wanted to do something about it. And so their first attempt to sort of combat air pollution that came about in 1963. That statute had all sorts of problems, and so they tried again in 1967, which also was inadequate for a number of reasons. And finally, they enacted the 1970 amendments to the Clean Air Act, which is the framework for what is the modern Clean Air Act. They amended it again in 1977. We'll talk about some of the programs that came along with that, and again in 1990. So when Congress enacted the 1970 amendments to the Clean Air Act, it was particularly concerned with 5 pollutants, which they called criteria pollutants. And we're going to talk about each of those right now. So the first one is particulate matter, PM. There are a lot of acronyms that we're going to go through today. In fact, in a recent DC Circuit decision, Judge Kavanaugh made a snarky remark that they love acronyms in EPA land. So today we're in EPA land. You'll probably learn at least 30 acronyms throughout this entire presentation, so brace yourself. So we have PM. What are the sources of PM? Well, PM comes from the incomplete combustion of carbonaceous fuels. I'll say it again, the incomplete combustion of carbonaceous fuels. So take, for example, a campfire. You have a carbonaceous fuel, the wood. And in a low temperature, low efficiency combustion process like that, what happens is not all of the fuel gets burned. And so some of it gets suspended and gets emitted into the atmosphere in part of the flue gases. So when you see smoke from a campfire, what that is unburned fuel, and that is a form of particulate matter. PM takes a number of different forms, but that's the principal one you should take away with today. So I'm going to reintroduce you to a concept you might remember from high school chemistry, and that is stoichiometric combustion. So the goal of stoichiometric combustion is that you take a unit of fuel and you have 3 products: heat, or the energy for combustion, water vapor, and this harmless little gas called CO2. What happens...
Sorry.
No problem.
Sorry.
Technical issue real quick. All right. So what happens at a campfire is you have an incomplete, inefficient, non-stoichiometric combustion. You're not taking all that fuel and converting it into energy, and so some of that fuel gets suspended up into the atmosphere. Last year when I did this lecture, I just got back from Denver, and there was a wildfire out in Colorado Springs, and unfortunately just another one last week. So you see here a picture of wildfire. I should probably change my slides, but they're very unfortunate and tragic that they have them. But when you see a wildfire, you see all that smoke coming off the wildfire, and that is technical issue again.
Yep.
That's all right.
Sorry.
That is particulate matter, so it's unburned trees being emitted up into the atmosphere. So you also see PM come from higher temperature combustion processes like coal-fired power plants. So here you see a coal-fired power plant stack, and you see there all that gray smudginess is basically unburned coal being emitted up into the atmosphere. So the darker it is, sort of the unhealthier it is because it's more coal particulate that's being emitted in the atmosphere. If this was clear, it'd be more water vapor, and that'd be healthier because that's more stoichiometric combustion. So this picture is probably from a older coal-fired power plant. In terms of the environmental effects of PM, what kind of contributes to this smudginess, and so visibility is significantly reduced due to wildfires, and also the very small PM contribute towards regional haze, which is sort of the smudginess is way off in the distance, so you can't see as far. Well, the health effects is it causes lung tissue damage. You basically breathe the particulates into your lungs, and they cause lung tissue damage and all sorts of cardiovascular related issues. In addition to PM that comes off from the combustion process, you can also get gases from the combustion processes that absorb onto small dust particles like mercury and selenium. And when you breathe those into your lungs, your body has a hard time getting them out. And so it causes all sorts of health problems when you breathe those into your lungs. So significant health impacts with PM. The next criteria or pollutant we're going to talk about is carbon monoxide, CO. The sources of CO, again, is the inefficient combustion of carbonaceous fuels. The principal source of CO in this country is our motor vehicles. I'd say about 80% of CO emissions come from motor vehicles, and it's because motor vehicles are very inefficient at converting fuel into locomotive force, particularly older ones like this Volkswagen van. So what you have in the combustion process essentially is you have the carbon, and the goal of stoichiometric combustion is to fully oxidize that carbon and turn it into CO2. But when you have an inefficient combustion, it doesn't fully oxidize, and it's just CO, and that's where it comes from. Arnold Wrightsey, who is a prominent professor formerly at GW, describes automobiles as their principal function is air pollution with a side effect of moving you around. The point being, cars, particularly old ones, are very inefficient vehicles, and they contribute a lot to these CO emissions. In terms of the health effects of CO, are there any doctors in the room? Good, I can say whatever I want. What happens is your hemoglobin, the job of your blood cells is to go to your lungs, pick up oxygen, and deliver it to the tissue in your body. With CO, your blood cells go to pick up oxygen, and they get fooled, and instead of picking up O2, they pick up CO, and then they actually can't ever get rid of that CO molecule. So two things really happen. One, the tissue that was going to be the recipient of that oxygen doesn't get the oxygen it needs. And secondly, your blood cell is just inefficient, it's poisoned. So it's not like you can breathe a bunch of carbon monoxide, run outside, get some fresh air, and be okay. If you breathe too much CO, it will actually kill you because it poisons your blood. In terms of the environmental effects, really quickly, of CO, there's not as many. It also harm anything else that has hemoglobin. But when we talk about carbon monoxide, we're principally concerned with human health impacts. All right, so we are going to deal with two different criteria pollutants during one slide. So the first is nitrogen dioxide, NO2, and ozone, O3. So NO2 actually comes from high efficiency, high temperature combustion processes. So as engineers are trying to get rid of PM and CO emissions by making the combustion process more efficient, what ends up happening is you actually get a lot more NO2 emissions. And so this is just one example of how there are no easy solutions in air pollution control law. When you solve one problem, you almost inevitably create another problem. And The reason for this is these vehicles, so of course this is a picture of a Porsche here, I think that's a Porsche, and they create a lot of NO2 emissions because they're much more efficient at combusting gasoline than the old Volkswagen Bug I just showed you. But what happens is these vehicles burn atmospheric air, which is made up of some 78% molecular nitrogen, N2. And at high enough temperatures, the molecular bond between those nitrogen molecules will break, and it forms N. And they're very oxidizable. They like to react with other molecules. And so in the combustion process, it'll combine with oxygen to form NO, NO2, NO3, or NO4. Those are collectively referred to as NOx, the X representing a variable between 1 and 4. But the principal pollutant that Congress was concerned with was NO2, which is the criteria pollutant. I think about 60% of NOx emissions in this country come from automobile vehicles. 30% come from just combustion processes at industrial facilities. So 90% of NO2 comes from combustion processes, and that's because it requires a high energy, high efficient temperatures to create NO2. So NO2 is very reactive, and so when it goes up into the atmosphere, in the presence of unburned hydrocarbons and heat, it will form into smog. And you see here a picture of LA, a lot of smog. On really bad days, you can't even see the mountain ranges from LA. And smog is made up a lot of ozone, ground level ozone, O3. So ozone can be created from combustion processes, but principally it comes from this photochemical reaction in the atmosphere when other pollutants like NO2 and unburned hydrocarbons get in the atmosphere, and at hot temperatures they create, through a photochemical reaction, smog. Today, you see the ozone alerts. Today I think DC is a yellow, which means moderate conditions, so it's not unhealthy to breathe. In hotter temperatures, you'll start seeing orange ozone alerts, which means it is safe for the general population, but children, the elderly, or people with asthma shouldn't go outside. And then red are big ozone alert days where it's unhealthy for everyone and you should stay at home. And so, for instance, in Denver, which has a lot of ozone problems, if they know there are very hot days coming up, you'll see signs on the side of the road that say, please consider taking public transportation tomorrow. And the whole purpose of that, of course, is if there's fewer vehicles on the road, there's going to be fewer NOx emissions that get emitted up into the atmosphere, and there's going to be less ozone created as a result. All right, in terms of health effects, ozone is a strong oxidizer. It actually oxidizes your lung tissue and causes very serious lung damage. It also can oxidize crops, so there's an environmental component as well to ozone. Moving on to our next criteria pollutant, which is sulfur dioxide, SO2. So SO2 is a little bit different than the criteria pollutants we've talked about so far. SO2 is created in both low efficiency and high efficiency combustion processes. Where it comes from is the combustion of carbonaceous fuels with sulfur in them. The principal one in this country is coal, so you see that here on the slide. But you get it from all of the fossil fuels. You get it from crude oil, diesel, gasoline naturally has a lot of sulfur in it before they clean it out in the refining process. So in the combustion process, you have sulfur, it's an S, and it gets oxidized to form SO2. In terms of the environmental effects, it can create this haziness. And the ultrafine SO2 particulates actually contribute to regional haze, and so that's the sort of off in the distance smudginess. Visibility in the east is severely limited compared to conditions out west because of SO2 emissions, principally in the Midwest that get carried over to the east through the wind patterns. But more importantly, what we think about when we think about SO2 is this sort of environmental damage, and that's from acid precipitation. So the SO2 goes up into the atmosphere and interacts with water vapor. So SO2 plus H2O equals H2SO4, sulfuric acid. And that sulfuric acid doesn't stay up in the atmosphere forever. It comes down in the form of acid precipitation, acid rain, acid snow, acid fog, and causes severe environmental impacts, as you can see from this photo. What happens is it actually increases the acidity of the water bodies, and when the trees and plants take that up, it causes them to be unhealthy. In terms of health effects, it's not as many. It's primarily environmental impacts that we are concerned with SO2, but fine particulates in their condensable phase, or SO2 in its condensable phase, can lead to the formation of very, very fine particulates. And as I mentioned earlier, when you breathe fine particulates into your lung tissue, it can cause lung tissue damage. So increasingly, we're starting to realize that there are health impacts, human health impacts as well with SO2. So those are the 5 criteria pollutants that Congress was principally concerned with when it enacted the 1970 amendments to the Clean Air Act. But it also gave Congress, or EPA, the ability to add additional criteria pollutants. And the only one that they've ever added is lead, and that is in response to litigation brought by NRDC in the 1970s. So where do we get lead? Well, it comes from the combustion of leaded gasoline. Well, who put leaded gasoline in the car this week? Nobody. And so the principal control measure to get rid of lead emissions is to phase out the use of leaded gasoline. But why do we put lead to begin with in gasoline? Lead's not there naturally. Well, in the 1950s and the 60s, engineers realized that if they added a little bit of lead to gasoline, it actually evened out the combustion process and made it run more efficiently. And so that's why they added it. Again, an unintended consequence. So when they started phasing out the use of lead, once it was listed as a criteria pollutant, these engineers' children came up with this new chemical, MBTE. They thought it was a miracle, so they added that to gasoline, and things were great for a good 10 years until they realized that it is a strong groundwater contaminant, and that any underground gasoline tank that's leaking is going to be shooting out MBTE like a plume, and they started to phase that out as well. So, again, unintended consequences. What are the health effects of lead? Well, it'll kill you. I don't think I need to say too much more about lead. It is very dangerous, and that is why it was added as a criteria pollutant. So now we've talked about the 6 criteria pollutants. Before we talk about, yeah, you have a question?
Sorry, yeah, about lead. So lead paint regulation.
Uh-huh.
Is that not under the Clean Air Act? Is that under like local building codes? You know? Sure. Sorry, so my question was about regulations around lead paint in old buildings and whether or not that's covered under the Clean Air Act or that's addressed in local building codes or some other type of regulation.
Yep. So the question is, do I need to repeat it? Okay. Is lead paint regulation, whether or not that's addressed under, like, I think building codes and paint you're talking about, whether or not it's addressed under the Clean Air Act or some other statutes. And the Clean Air Act doesn't address lead paint or anything like that. It will address lead emissions, and we'll talk a little bit how it does that. But the Clean Air Act doesn't touch things like indoor areas like that. So that's, I'm not sure exactly what statute would regulate that. I don't know if is it hazardous?
Yeah.
Okay. TSCA, so it could be hazardous waste. Any other questions about these criteria pollutants before we head on to how we go about regulating them? All right. So EPA is required to establish National Ambient Air Quality Standards, NAAQS. Got another acronym for you. And so EPA basically decides what is the amount of pollutant that it is safe to breathe in the ambient air, so we're not talking about indoor air, but ambient air for each of these criteria pollutants. Importantly, EPA is allowed to consider uncertain science, so there could be a margin of error when it sets these allowable levels, and it cannot consider costs. So if EPA were to decide that no amount of lead is safe, it doesn't matter how much it costs the economy to comply with that standard, they have to do it. And if you think back at the beginning of the lecture about what was the genesis of the Clean Air Act, I think it sort of makes a little more sense by why Congress would set such a stringent regulation. It's a health-based concern, and they wanted to make sure that the health of the public was protected. And these standards are expressed as a maximum acceptable mass for a period of time. So essentially, EPA basically takes a cubic meter of air and it asks how much of each of these criteria pollutants is it safe to breathe. They do it for SO2, they do it for PM, and they set a different NAAQS for each criteria pollutant. EPA is required to establish both a primary and secondary NAAQS. Primary NAAQS are designed to protect human health, and secondary enacts are designed to protect human welfare and the environment. Over time, EPA has interpreted primary very broadly, and sort of the distinction between them has become blurred. It's not as important. In fact, the only NAAQS for which the primary and secondary NAAQS are different is SO2. But it's becoming increasingly important. Recently, I guess in the context of the ozone NAAQS, there's some statements by EPA in the rulemaking documents that perhaps the NAAQS isn't sufficient to protect against environmental damage, oxidization of crops, for example. And they're arguing, though, then you need to set a secondary NAAQS that is lower than the primary NAAQS for that reason. In addition, if CO2 were ever added as a criteria pollutant, this distinction would be important because there's not a lot of primary human health impacts when we think about CO2. Usually we think about sort of welfare, climate change, sea level rise. Those are secondary impacts. And so if CO2 is ever to be listed as a criteria pollutant, the secondary NAAQS, the distinction between the primary and secondary NAAQS would come into play again and be very important. And so the Clean Air Act has this notion of attainment and non-attainment. If you are below the NAAQS level, it means you're breathing a healthy amount of air and you are in attainment with the NAAQS standard. If you are above it, it means you're breathing an unhealthy amount of air and you're in non-attainment. So in a fit of optimism, in the 1970 amendments, Congress said that the whole country needs to be compliant with the NAAQS by 1975. We haven't quite met it. Even today, there are several areas of the country that are not in attainment. And to be fair, EPA keeps lowering the number based on new science. So EPA always lowers the number, never seems to get greater. But we just haven't quite met that goal. And so in the 1977 amendments to the Clean Air Act, Congress kind of established this new source review program, which established different standards that apply to non-attainment areas and attainment areas. So I had a better understanding that it wasn't going to be quite possible to make attainment by 1975. The EPA is required to review the NAAQS every 5 years. Sometimes it takes a little bit longer than this, and often this can depend on political will. During the Bush administration, a lot of the NAAQS deadlines sort of slip a bit, but then in the first term of the Obama administration, they went ahead and reviewed all 6 criteria pollutants. So I think right now we're up to date. And of course, every NAAQS that gets issued is a challenge. I think every NAAQS that's ever been issued has been litigated, and so it takes time to resolve these, and often it's not till 5 years after an NAAQS is issued that it's settled that is going to be upheld by the courts. So the Clean Air Act in Section 107 divides the whole country up into what are called AQCRs, air quality control regions. And these are basically county level areas. There's some exceptions to that. For instance, in the AQCR you're in right now includes DC, Northern Virginia, and Southern Maryland. But generally it's a county level basis that it divides up into these AQCRs. And you ask whether or not you're in attainment or not for each AQCR. So it's not, is the whole country in attainment? It is each AQCR in attainment? And you do that analysis for each of the criteria pollutants. So one AQCR can be in attainment for SO2, but not in attainment for NOx. And so then each state is required to develop, now that EPA has set the standard, told states what is an acceptable amount of air pollution for each of these criteria pollutants, the states are then tasked with figuring out how to go about getting to that level of healthy air. And so states develop what are called state implementation plans, which are a compendium of state laws, regulations, aimed at going about how to achieve the federally set NAAQS. So we have this notion of cooperative federalism. I think Congress is pretty wise in this regard because the decisions you have to make in air quality planning are best left for local decision makers. For instance, if an area has to decide whether or not they need to shut down a steel mill or a chemical manufacturing plant, they better know, what their workforce is suited for, and they can make those tougher decisions. You don't want federal EPA to come in and say, well, you need to shut down your steel mill. That would cause a lot of controversy. And so the way the Clean Air Act is structured, it leaves states with those hard decisions, and also the first chance at figuring out how to go about achieving these standards. And this notion of, oh, you have a question? Yeah.
Are the state Are the state implementation plans revised every time the NACs are revisited, or how does that work together?
So the question is, are the SIPs revised every time the NACs is revisited? And the answer is yes, if the NACs is changed. So EPA is required to review the NACs every 5 years, but it doesn't necessarily mean that they're going to change it. So when they do change it, it's a long process. So sometimes you'll see in the next slide, we'll talk about the process and the fact that EPA can issue a federal implementation plan, maybe in the interim, to allow states to get in line. But anytime the NACs are changed, the states need to revise their SIPs to comply with that new NAC standard. And so this notion of cooperative, oh, another question.
What is the incentive for the state to actually create an effective state implementation plan?
Oof, that's a good question. The question is, what is the incentive for the state to create an effective state implementation plan? In about 4 slides, we'll talk about the enforcement tools that EPA has. You'll see that EPA can restrict federal highway funding. They've never even threatened to do that, but the fact that they can do that gets states to kind of come into line. And I may have some characters of states as we go throughout this lecture, but generally states, they have pretty sophisticated air quality programs, and they want healthy air for their citizens as well. So it's pretty cooperative in that sense that they're going to come in line with EPA, and they want healthy air as well.
I'll throw in one additional aspect of that, which is every time a state revises or does a new SIP, it has to be approved by EPA as meeting certain minimum requirements in the Clean Air Act. And if a state fails to do that, what happens, sort of to everyone's chagrin, is EPA issues a federal implementation plan, or a FIP. So if a state wants to stay in control of its own implementation of the Clean Air Act, that is a sort of more practical, on-the-ground incentive for them to have a SIP that at least, meets the requirements in the Clean Air Act, which doesn't, as Ryan has explained, necessarily get you to achievement of the NACs and so on and so forth, but it makes a difference.
I'm glad you guys are interested in this topic, because the case that Madeline argued is really, this is the central issue. So we will talk about this more in a bit. But it's a good question, because it's coming out now, and the new GHG PSD rules, Texas isn't really wanting to come along and adopt those rules, and so there's a struggle between EPA and states on this issue. So this notion of cooperative federalism has been upheld by a lot of recent decisions. For instance, in EME Homer City Generation v. EPA, that involved a challenge to EPA's cross-state air pollution rule. Relying on the Good Neighbor provision and another provision of the Clean Air Act, EPA has promulgated a series of rules designed at regulating NOx and SO2 emissions that contribute to downwind states' non-attainment with the NACs. First, they issued a SIP call in 2003. In 2005, they issued the Clean Air Interstate Rule, CARE, which was vacated or sent back by the D.C. Circuit, but left in place until EPA promulgated a new rule. The Cross-State Air Pollution Rule, CASPR, was that rule. And what it did was basically designated how much each state significantly contributes to other downwind states' non-attainment of the NACs, and established a cap-and-trade program of SO2 and NOx emissions. And it covered 28 states in the eastern part of the United States. When it went up to the D.C. Circuit, the D.C. Circuit said, no, EPA, you made a finding that certain states contribute to downwind non-attainment, and on the same day you issued this federal rule about how to go about fixing that. You're allowed to make that first decision that they are substantially contributing to their non-attainment, but then you have to give states the first opportunity to fix that. And only if the states don't address that non-attainment and that contribution, then can EPA come in and issue a federal implementation or federal rule. So it kind of ties into this next slide here, which is that states have to submit their SIPs to approval for EPA. And usually this is sort of a negotiation process between EPA and the states, and they go back and forth to make sure that they have an adequate SIP. So if the SIP meets the section requirements of Section 110 of the Clean Air Act, then EPA can approve it. Those are the minimum requirements that must be met. We'll talk about them on the next slide. But EPA can approve the SIP in whole. It can approve it in part. And as Madeline mentioned, if a state's SIP is inadequate, eventually EPA can just say, okay, we're going to issue a federal implementation plan and take over permitting in that area of the country. Now, before 2011, EPA had never issued called an unfriendly FIP. So which is basically, you're not doing it right, we're going to come in and take over your air permitting. And I think that's for the reason I mentioned that states want to, better air quality for their citizens. But in 2011, whenever the greenhouse gas PSD rules came into effect, we'll talk about in a little bit, Texas said, nope, we're not doing it. And EPA said, yes, you are. Here's your unfriendly FIP. And that's one of the issues of the case Madeline was involved in, and so we'll talk about that more in a bit. EPA has 1 year to approve a SIP, but that deadline may slip. I think it's been, do you know how long it's taken maybe 6-7 years to approve a SIP? And it's unfortunate because states are sort of in limbo during that time period. Sources, more specifically, when they get a new permit, they have to kind of comply with both sets of regulations, the existing SIP approved regulations and then the new state laws. But by statute, EPA is supposed to approve it within a year. And then EPA also have what is called overfiling authority. So if a state submits a SIP that is approved by EPA and deemed to be sufficient, but maybe 5 years down the line, there's a change in administration, or the state just doesn't want to enforce its rules, EPA can come in and file in federal court a lawsuit to enforce the state law provisions. And citizens as well can enforce most of the provisions of the Clean Air Act under the citizen suit provision. So I mentioned the requirements of a SIP are laid out in Section 110 of the Clean Air Act. This is just a few of the examples of what needs to be in there, not all of them. But states have to be able to establish enforceable emission limitations or control measures. They can't just say, pretty please source, reduce your emissions. They have to go in and be able to enforce that. They have to collect air quality data, prohibit sources from contributing to non-attainment of the NAAQS. So if EPA knows that a particular source is contributing to non-attainment, or the state knows that a particular source is contributing to non-attainment, they have to be able to go in there and shut them down or require them to control their emissions better. And there's also monitoring and reporting requirements. And of course, as Emily mentioned, they have to be able to revise their SIP to come into compliance with any changes. So this slide is meant to just sort of give you an example of what requirements apply if you're in a non-attainment zone. And so this is the non-attainment requirements for ozone. And as you'll see here, it sort of divides it up into different levels of non-attainment. So if you have marginal non-attainment, that means your hair is kind of unhealthy but not too bad, all the way to severe non-attainment. And that's areas like LA, Denver, and recent history, Houston. And so if you're in marginal non-attainment, under the non-attainment requirements, you have to take a emissions inventory, so you have to know where all the emissions are coming from in your area. It's expensive, but not terribly difficult to do. Existing sources have to install RACT, another acronym, Reasonably Available Control Technology. I think I'm already up to like 20 acronyms, and we're not even that far. So maybe 50 acronyms today. New sources. Major new sources have to undergo what is called new source review. And if you're in a non-attainment area, you have to install the technology known as LAIR, which is the lowest achievable emissions rate, which is a very stringent technology, basically the best technology in practice to control those pollutants. Then as you get further in, you get more stringent requirements. In moderate non-attainment, you have to have an offset ratio. So say you're going to construct a new source in a non-attainment area that's going to result in 100 tons per year of NOx emissions. Well, if you want to do that, you have to get reduced NOx emissions at that same source, maybe by shutting down one of your old units by 110 tons per year, or you need to go to another source in the same AQCR and get them to do that. And notice that it's not 100 to 100, it's 100 to 110, because the goal in non-attainment areas is reasonable further progress. You're trying to slowly get towards attainment. And so these offsets are geared at trying to reduce emissions in the area. And then all the way down to severe non-attainment, you get something like reduced vehicle miles traveled, so increased public transportation. All right, so that's non-attainment. What applies if you're in attainment? Well, that is the Prevention of Significant Deterioration Program. And as the name implies, the goal in PSD areas is you have healthy air, good job. The goal is to prevent you from slipping into non-attainment. And so all AQCRs are designated either a Class 1, Class 2, or Class 3 area. Class 1 areas are like national parks, so areas that we really want the air quality to be pristine, make sure that there's no visitability impacts in those areas. And then everything else is just Class 2. There's no Class 3 areas. Makes it easy. And again, the idea is to make sure that you don't slip into non-attainment in these areas. And new major sources are required to undergo pre-construction review, just as they are in the non-attainment program. And you are a major source if you have the potential to emit 100 tons per year of any air pollutant, criteria pollutant, if you're one of 28 listed source categories in the statute, or 250 tons per year if you're any other type of source. And so those sources then have to install what is required best available control technology, BACT, for all pollutants that are emitted in a significant amount from that source. So if you're a major source, you have to undergo this review, and on the next slide we'll talk about how you go about selecting BACT. And also, these major sources have to undergo air quality monitoring and modeling. So they have these very complex models where they take all the existing sources of emissions and then they add in the new sources of emissions, and they determine whether or not there's going to be any NAAQS violations that result as a result of the construction of the new source. All right, so BACT. How do we figure out what is the control technology that needs to be installed? Is a 5-step process, according to EPA, I guess. There are some states that don't necessarily follow this approach. And step 1 of the process is to identify all available control technologies. There's been a lot of litigation under this step. And the question is, how broad do you have to consider other control technologies for a source? For instance, if you're going to build a new coal-fired power plant for the purpose of providing electricity to heat homes in the winter, do you have to consider also sending everyone a box of sweaters instead? The answer to that is no, but you have tighter questions or more difficult questions. For instance, if you're going to build, again, a new coal-fired power plant, do you have to consider IGCC, which is Integrated Gasification Combined Cycle Technology, which basically takes coal, it gasifies it, turns it into a synthesis gas, and it removes the contaminants, and then you combust the syngas, and it's a cleaner way of burning coal. Prior to 2005, EP said, no, you don't have to consider that. That's a different type of source. But since then, EPA has kind of reversed that guidance and said, well, no, there may be some instances if it doesn't redefine the source that someone that wants to use coal has to consider IGCC as part of the BACT analysis. So you see here on the slide, the rule is you don't have to consider things that redefine the source. So you look really at the business purpose of the source and you determine whether or not they could potentially use a different type of technology and still be consistent with their business purpose. For instance, if your purpose is to use a particular type of coal, you don't have to consider natural gas as a alternative fuel. All right, so once you've identified all the control technologies, you move on to step 2. And in step 2, you eliminate anything that's technically infeasible. This is a pure technical analysis of what is not capable for being installed on that source. For instance, selective catalytic reduction technology is a technology that is used on coal-fired power plants and a lot of other sources to control emissions of NOx. But for certain sources that burn a particular type of coal, they can't use SCR because the contaminants in that coal actually poison the catalyst. So for those sources, they don't have to really consider SCR because it's technically infeasible. It wouldn't work on that source. So in this step, you sort of look at all the technical feasible options, and the ones that are infeasible, you kick them out of the process. Carbon capture and sequestration, there's a lot of litigation going on now as to whether or not that is technically feasible. EPA has said as a general matter, it is. Sources should consider CCS to be technically feasible, but some sources have been able to get CCS out of the BACT analysis by saying It's not close to a reservoir to accept the CO2. There's no pipelines nearby. So sometimes CCS can be eliminated at step 2 if it can be shown it's not technically feasible for that particular source. Step 3 is an easy one. Just rank them based on their control efficiencies. So the most efficient control, and the best technology is first, all the way to the last one. And then in step 4, you sort of have this case-by-case analysis of the energy, environmental, and economic impacts. So you start with the most efficient control technology, and you analyze how much it's going to cost. The economic impacts is sort of the focus of this analysis, as you might imagine. And you figure out how much money it costs, basically on an incremental basis, per ton of SO2 removed to use that more efficient technology. For instance, it could cost $1,000 more per ton of SO2 removed. And then the question is, well, then do you have to install that technology? Is that too expensive? Some permitting authorities will publish the actual amount by which, if it is below that amount, you have to use that technology. If it's above, you don't. So if it costs $950 per ton of SO2 removed, if $1,000 is the threshold, then you have to use that technology. You can't eliminate it. Or if it's $1,500, you can eliminate it, and you don't have to install that control technology. Other permitting authorities don't do that. So it's sort of a wishy-washy analysis of whether or not you can get the permitting authority to agree that it would be too expensive to install that technology. In CCS, carbon capture and sequestration, to the extent is not eliminated in step 2 of the analysis, is often eliminated in step 4 based on cost. It's very expensive right now to employ CCS because it's still sort of in its pilot stages. So this is the mechanism by which a lot of these new sources are not having to use CCS. And step 5, another easy one, you just select the top remaining option. Any questions about the 5 steps of BACT? And again, this is for new sources or major modifications of existing sources in attainment areas. Yeah, question? In the back?
Yes, please. Just one moment.
You said these are used for attainment areas. Why not non-attainment areas? Why do they just have the reasonable available control technology?
So non-attainment areas, they have an even more stringent requirement. It's a similar analysis like this, but they have to install the layer, which is the lowest achievable emission rate. And it's basically identify all the potential control technologies, and you take the most efficient one, and there's no real consideration of costs. This is the best demonstrated technology. I shouldn't use that term because that's another acronym in a different context. But yes, it's the highest, most efficient pollution control technology. Anything else about BACT? Yeah.
So is this only going to
Mike.
be... Would the BACT analysis only be revisited if there were a major modification? Otherwise, if a facility were just operating for 25 years under a standard that was acceptable whenever it was built, it could sustain that.
Yeah. So the question is the BACT analysis ever revisited if there's no major modification? And the answer is no. This is a pre-construction program. And so once you get your pre-construction permit, once you get your permit, you construct your source and you can operate. Only if you have a major modification do you then have to go revisit the BACT analysis. So you can have sources that are 40 years old that are still cooking along. And as long as they don't make a major modification, they're not going to trigger this analysis.
I was just wondering if you see litigation at step 4 in terms of the cost, because I feel like the relative cost of different technologies over the life of a major power plant, for example, might be something on which experts would disagree.
Oh, absolutely. So the question is, it's kind of the fact that you have to consider economic impacts. There's not a lot of certainty to that, and there's a lot of experts that would probably disagree on how much it costs for each technology, and they certainly do. But what you do is the applicant is submitting their application, and they have their experts, and they say these are what our experts say and how much it would cost. And who you're trying to convince usually is the permitting authority. If they agree, they'll accept that analysis. Of course, they'll analyze it carefully. They put that out to public comment. And then a lot of times if people that are against the project will comment on that analysis and say it's not sufficient, they can challenge the permit in court as well. So a lot of litigation around whether or not something is truly properly eliminated as economically unviable. Anything else on BACT? All right, good questions. So, getting to your question, it's a horrible picture, I know. So, what if a state says, you know, forget it, we don't care about air quality, our elderly can move to Florida if they don't like it. What tools does EPA have to sort of enforce it? And they have quite a few. First, as I mentioned earlier, is federal highway funding restrictions. This is the sort of nuclear bomb of their tools. And as far as I know, or Madeline knows, they've never even threatened to restrict federal highway funding. But the mere fact that they have that as a tool probably gets states into line. If you want to see a congressional delegation light up on fire, you threaten to remove their highway funding. The one they more often use, or the one they used in the case of Texas, is the creation of a FIP, and basically control of the AQCR. So if a state's not coming on with their state implementation plan, it's not adequate, or they refuse to adopt the greenhouse gas rules, then EPA can come in and say, okay, in Texas, the EPA Region 3 in Dallas, Texas office is going to run your state permitting program for greenhouse gases. And that's not ideal in a lot of senses because they don't have as many resources, and so it takes a much longer time to get a permit in Texas now than it does in other sort of states. So there's significant consequences to that. And states generally want control of their own state permitting program. They can increase offsets. So as I mentioned earlier, in non-attainment areas, there's usually like a 1.1 to 1 or 1.2 to 1 ratio. EPA can say 2 to 1. And that would effectively make building a new source almost impossible in those areas. And then finally, EPA can simply refuse approval of all construction permits. No new construction, development's halted, and that is a significant tool, obviously, as you might imagine. And I have a note on the slide here, and importantly, EPA can also challenge individual permits. So in Alaska v. EPA, Alaska had permitted a new source, a coal mining facility, I believe, in Alaska, and EPA didn't agree with its backed analysis. And so EPA commented on the draft permit, as I mentioned, the process you can comment on these draft permits, and the state said, no, and they issued the permit anyway. And EPA challenged it, and they were actually successful in vetoing it, and the Supreme Court affirmed EPA's authority to veto individual permits. So this is just yet another reason for states to listen to EPA. These are pretty powerful tools, as you might imagine. All right, so this is a review of air quality planning, what we just talked about. So Section 108 lists the criteria of pollutants. Section 109 sets the NACs for each criteria pollutant. 107 designates the AQCRs. 110 talks about the creation and adoption of state implementation plans. 160 through 169 are the attainment area requirements, which is the prevention of significant deterioration. And 171, that's for new sources. 171 through 193 is the non-attainment area requirements. Let's take an even bigger step back and look at the big picture, the Clean Air Act. So you see here, Title I, air quality planning. That is what we have gone through, and now it's been 50 minutes. Wow, 50 minutes. As you might imagine, we're not going to get into that level of detail of each one of these, but the whole purpose of this slide is really to sort of give you just a big picture idea of what is in the Clean Air Act. So Section 112 of the Clean Air Act regulates hazardous air pollutants. So these are really dangerous air pollutants that cause cancer. And it sort of, Section 112 lists, I think, 180 different hazardous pollutants that it regulates, and it sets categorical standards, or it requires EPA to set regulations on a categorical basis for these hazardous air pollutants. It's a very command and control. This type of facility needs to install this type of technology. And the standard is MACT, which is the maximum available control technology. It's even higher than layer, I think. And so that's what they have to install. New source performance standards. So we've been talking a little bit about new source review, and it's often confused with new source performance standards, which are entirely separate. They both apply to new sources, but through new source performances, or basically EPA can say, well, we don't trust the states to set these back limits or choose the appropriate technology. So they could say any new refinery in the country is going to have to meet these minimum standards and just promulgate a new source performance standard. And if you build a refinery, you have to comply with those requirements. It's not difficult to comply with. If an NSPS applies to you, you just look at the standard and you can expect to see all those requirements in your permit. There are some questions, stuff I've done as well, research on is whether or not NSPS applies. But if it does apply, then you just have to comply with that. But in a lot of ways, the new source review sort of makes new source performance standards not as important, because new source performance standards are static in time. So you promulgate a new source performance standard in 2000, and that is based on a particular control technology. Although there are emissions limits, usually EPA has in its mind what technology would be required. But as time progresses, new technologies come out, and it's very easy to meet those emissions limits, say in 2013. But the new source review is a case-by-case analysis, and so often that is what governs the technology that needs to be installed. But NSPS sets the floor for a backed analysis. If you're going to build a new source, whatever technology or emissions limits you have cannot be lower than the NSPS standards. So it's a good floor-setting mechanism. And when we talk about greenhouse gases here shortly, I'll talk about the NSPS for EGUs. So there is a new source performance standard being promulgated for greenhouse gas emissions. Very controversial. We'll see why. Title I also has enforcement provisions, and as I mentioned, has the non-attainment and PSD requirements. Title II is an entire program designed at regulating mobile sources. So we've been talking about stationary sources. Title II regulates mobile sources, regulates emissions from vehicles, regulates gasoline, the sulfur content in gasoline. There is a new light-duty vehicle rule, which regulates CO2 emissions from new light-duty vehicles. So there's a lot of different programs within Title II, very complicated. There's also renewable fuels requirements that come from Title II. In the trade pest, there's a lot of reference to what's called the ethanol blend wall, and that's relating to the renewable fuels requirements in Title II. So Title II regulates mobile sources. Title III is where you actually get the definitions. So we've gone through all that and finally get the definitions of everything. It has the citizen suit provision. The reason it's third and not first is because the Senate drafted the 1970 amendments to the Clean Air Act, and they had a practice of putting the definitions last. Title IV is noise pollution. I don't even know what that is. So it's
Don't ask questions about that.
Basically, I've never come across it. I think I remember briefly talking about it in law school, but it's not as important. If your neighbor is being really loud, maybe you can take a look at the noise pollution, and perhaps you can file a lawsuit under the Federal Clean Air Act. I'm sure they won't see that one coming. You don't have to worry about noise pollution so much. Title 4A is the acid rain program. So that came about in the 1990 amendments to the Clean Air Act, and what that does is establish a cap-and-trade program for SO2 and NOx emissions from utility sources. So unlike the command and control approach that we've been talking about, this actually is a market-based incentive system, and it's worked pretty well. Basically, every ton of SO2 that's emitted from a utility is assigned an allowance, and you can't emit over your allotted amount. If you go below that, you can sell your excess allowances. If you go above that, you have to go and purchase allowances. So it gives the regulated community the decision to decide whether or not they would prefer to install a new control technology and sell credits, or if it's cheaper for them to just go and buy credits. So it's a market-based approach to regulating SO2 and NOx. Title V, also added in the 1990 amendments to the Clean Air Act. What happened is, prior to Title V, sources would have a number of different permits, and sometimes the requirements would conflict, and it was very difficult for people to figure out what standards apply to a source. You could have your original pre-construction permit, and then a modification construction permit, and it was very confusing for sources, and also, of course, the general public to figure out what applied. And so the goal of Title V was to take all those requirements, put them in a single operating permit, so you can easily tell what requirements apply to a source. And it is an operating permit, so you have to renew it every 5 years. One problem with this is while it could have been great for sources if this was their new permit, all your old permits continue to be enforced. And so while you're putting everything into the operating permit, you still have to comply with your old permit. So if you have inconsistent permits previously, you still have inconsistent permits and you have to deal with it. Title V also requires that sources have adequate monitoring and record keeping and sampling. So increasingly, sources, or at least environmental groups, have been pretty successful at whenever a source has to get a new Title V permit, challenging whether or not the monitoring requirements are sufficient to ensure compliance with all the standards. And if they're not, they can require sources to actually install new monitoring equipment. So even though it's supposed to just be this provision where sources have a single operating permit, sometimes sources actually have to modify their source as a result of these Title V permit renewals. Title VI is stratospheric ozone protection. So this regulates CFCs, HCFCs, everything that results in a depletion of stratospheric ozone. And it's really an outgrowth of the Montreal Protocol. And it's been very successful at regulating and getting rid of ozone depleting substances. Very big picture overview, I know, but do any of you have any questions about the big picture? Yep, in the back. Nope, no.
You know, a couple weeks ago, Obama and the president of China met to discuss voluntary reductions for HFCs.
Mm-hmm.
And I was wondering if any of that pact or agreement, or whatever the correct term for what they decided, would factor into the Title VI section, or if that's something that's totally separate.
So the question is that Obama met with China a couple weeks ago to talk about voluntary reduction of HFCs and whether or not that was sort of an outgrowth of Title VI. I don't think it is. I think that is more of a source-based regulation. HFCs, though, have a very strong global warming potential, and so maybe that's more about a climate change type agreement, that if you get rid of HFCs, you're really limiting the amount of helping ameliorate climate change. Are you familiar at all with that meeting?
Yeah, I mean, my sense, maybe a tiny bit, but my sense is that's sort of getting out ahead of what's in the Clean Air Act,
So
as
that
they've.
meeting and the agreement isn't going to factor into updates to this.
The question is whether or not that meeting agreement is going to factor in updates of Title VI. I don't think so. They don't amend the Clean Air Act very often, but
Yeah. The Clean Air Act, I think, in this sense, is sort of a backstop or a floor, as it's often called. And, you know, people have learned more since it was enacted about exactly how you want to go about reducing these pollutants, and they're working on it, I guess.
Yeah. All right, so I have a question from the internet. It is, how does EPA delegate the sampling for attainment between employees and the states? I'm familiar with air quality, but does EPA get involved in sampling? That's a good question. So in the PSD and non-attainment, there are requirements that you, for new sources, or you have to have ambient air quality monitoring and sampling. I think that's part of the SIP, and so the state has the principal role in doing all the monitoring and sampling. I don't think EPA ever gets involved in that unless there's some sort of inadequate.
I mean, EPA independently does data gathering about pollutant levels as sort of inputs for its the NAC setting and things like that, and also, you know, taps into academic and private sector efforts to do the same. But in terms of on a source level, that would, if you have a SIP in place, that would generally be something that's in the permit or done by the state itself, as far as I know.
Mm-hmm. Hopefully that was adequate. It's a good question, but I think the answer is the states primarily have the role in sampling and monitoring, so long as they're the ones in control of their air permitting program. All right, any other questions about the big picture? Yeah.
I had a question about minor sources.
Sure.
Since PSD and non-attainment new source review only covers major, I feel like we're seeing more like small minor sources with gas compressors possibly change the air quality, and I don't know what the state's duty is to actually to deal with that, or EPA's duty as well.
That's a good question. So the question is, how does the Clean Air Act go about regulating minor sources? For one, they can be covered by new source performance standards. So as I mentioned, they don't have that same threshold as new source review of 100 tons per year, 250 tons per year. In addition, the thresholds for hazardous pollutants to be a major source for HAPs is lower as well. And they're also, they can, under 112, you can regulate area sources, so minor sources of HAPs. So there's certain ways that the Federal Clean Air Act regulates minor sources. But then states also often can go further than the Clean Air Act. They're not required to stick with the federal thresholds. And so in a lot of different state programs, they regulate those sources as well. Question in the back?
Hi, for Title II, does that cover any air pollution from agricultural, like farming, tractors or dust?
So the question is, Title II regulate air pollution from farming, like tractors? Yeah, I think tractors are regulated.
It's off-road.
Off-road, yeah. So
Yeah.
there are regulations for that. They don't regulate CO2 emissions for them yet, but they do regulate criteria pollutants from those. All right. Moving on then to climate change. As I mentioned earlier, this is probably a reason that a lot of you are here today, and for good reason, and because we are at the inception of how to regulate greenhouse gases under the Clean Air Act. Once in a generation this comes along. The 1977 amendments were one time where air lawyers got really excited because there was new rules about PSD and new source review. Again in 1990 when Title V and the Acid Rain program came out. And now, here we are learning or figuring out how to regulate greenhouse gases under the Clean Air Act. And as you'll see, it's not easy to do. It's sort of like fitting a square peg into a round hole, but EPA has sort of had to make do, and so far the DC Circuit has endorsed the way they've regulated greenhouse gases. So it starts with Massachusetts v. EPA, sort of the granddaddy of them all. And it's not going to go through all of the background, but to suffice it to say, there were competing interpretations within EPA about whether or not CO2 was an air pollutant subject to regulation under the Clean Air Act. In 1998, during the Clinton administration, there was a canon memorandum which said that CO2 emissions are within the scope. And in 1999, there was a petition to regulate CO2 from new motor vehicles. And then in 2003, EPA denied that petition. This is in the Bush administration. And so that petition denial eventually came up to the Supreme Court for review in 2007. The DC Circuit affirmed the denial, actually agreeing that CO2 was an air pollutant under the Clean Air Act. So what are the essential elements of the Massachusetts v. EPA? Well, the Supreme Court in a 5-4 decision said that greenhouse gases are an air pollutant. The definition of air pollutant is very broad in the Clean Air Act. It's pretty much any substance that's emitted into the atmosphere through some sort of process. And then EPA lacks the discretion to decide not to regulate greenhouse gases, and it has to determine whether or not greenhouse gases cause or contribute to air pollution which may reasonably be anticipated to endanger public health or welfare. And so it gave EPA 3 options when exercising that discretion. 1, find that GHGs do endanger. 2, that they don't endanger. Or 3, the scientific uncertainty is so profound that they just couldn't make a determination one way or the other right now. So they actually sort of gave EPA an out, allowing them to say that the scientific uncertainty was there, and a lot of people at the time thought that maybe the EPA would rely on that, but they didn't. And so in 2009, in response to another petition to regulate CO2 from new motor vehicles, EPA made an endangerment finding that greenhouse gas emissions from new motor vehicles do contribute, or reasonably, what's the language here, reasonably may be anticipated to endanger public health or welfare. So it sort of went through a summary of the scientific evidence in support. GHG, or the climate's warming, humans are doing it, and it went through the human health effects of climate change, which include increased temperatures, cause heat strokes, Air quality impacts. So as I mentioned, ozone, ground level ozone is created as a result of high temperatures, and so as the temperatures warm, more ozone is created. Also talked about extreme events, and then they also went through all the welfare-related effects of climate change, sea level rise, implications on water use, and energy and infrastructure impacts. So an endangerment finding has been made, which then require them, this is under Title II, to regulate CO2 emissions from new motor vehicles. And that came through the light-duty vehicle rule, and basically established CO2 emission standards from light-duty trucks and cars commencing with model year 2012. And this is sort of actually a result of a deal struck between EPA and the automotive industry. Under Title II, EPA is generally given exclusive authority to regulate motor vehicles because you don't want inconsistent state laws, but there's a provision which allows California to get an exemption to that. And they got an exemption, and they were already beginning to regulate CO2, and states are allowed to join in on the California program as long as they adopted wholesale. And what auto manufacturers didn't want is sort of this, dichotomy, two different programs and having to make different vehicles for different areas of the country. So they supported this single federal standards, so it's much easier on them. And the standards are essentially a fuel efficiency standard, because there's not a lot of post-combustion control of CO2. So the way you control CO2 emissions is you get more locomotive force out of a unit of fuel. I was at lunch with a friend the other day, and she told me about this 14-year-old that invented this contraption that you put on your tailpipe, and it has algae in it, and it absorbs 60% of CO2 emissions. So it's possible, the 14-year-old, amazing. It's possible that there could be some post-combustion control of CO2 for motor vehicles, but right now, the way we do it is we make vehicles more efficient. And you can see here some of the benefits of the rule. It's expected to reduce CO2 emissions by 950 million metric tons and save 1.8 billion barrels of oil. Sort of as an aside, I just want to note that EPA has established emission standards for model years 2017 all the way through 2025. These were finalized in October of 2012, just before the presidential election, to kind of understand that timing a little bit more. And in that rule, importantly, I think one of the interesting issues is that it incentivizes the production of electric and fuel cell vehicles. So these vehicles have game-changing potential in terms of CO2 reductions because they don't emit any CO2 at all, but they're not really adopted at the moment. And so the rule incentivizes it, thinking if it gives incentives for manufacturers to produce these vehicles, it will kind of spur the adoption rate and make them more widespread. The issues with electric cars, a lot of people are worried about range. I read a study not too long ago about a new recharging station that can actually recharge electric batteries within about 10 minutes. It's not going to be able to implement it for several years, but maybe down the line, just like you go to a gas station now, you can just charge your electric car in 10 minutes, and that would really be substantial in terms of getting CO2 reductions. But one of the issues with electric vehicles is Title II always regulates pollutants from the tailpipe. So for conventional vehicles, you measure the CO, the NOx from the tailpipe, and it's easy also to measure CO2 from the tailpipe as well. Well, electric vehicles don't emit anything. So the question is, do they just get a zero? They assign them zero as their CO2 emissions. And one of the incentives is to allow manufacturers to do that and through 2021. But the question really is, do you need to consider the upstream generation and emissions when you set that standard? So how much CO2 is emitted to generate the electricity at the power plant, which is then used in that vehicle. So in 2021, you're going to start assigning a value to these electric vehicles based on the estimated CO2 emissions due to the electricity production. And there's also a multiplier to incentivize it. And so by 2025, we'll be at 54.5 miles per gallon. So that's the light-duty vehicle rules. All right, so now that you've regulated, or you are regulating CO2 under Title II, the question is, what are the implications to other programs under the Clean Air Act? since EPA made an endangerment finding under Title II, doesn't automatically have to make an endangerment finding under Title I? And the answer to that question so far has been no. The language, the endangerment finding language in Title I is slightly different than the language in Title II, and EPA has sort of relied on those differences to say, oh, we don't have to make an endangerment finding under Title I yet. Importantly, if it does, what that means is it's a criteria pollutant and it has to go through all that NAAQS planning. So far, CO2 is not a criteria pollutant, but there are some areas of the Clean Air Act where there is this sort of automatic application now that you're regulating CO2 under Title II. And that is the purpose of the timing rule, which is to explain what is actually going to be regulated now. So it said that greenhouse gases are not currently subject to regulation at the time the rule was issued in 2010, but once the greenhouse gas standards for motor vehicles go into effect, they will be, which is January 2nd, 2011. And at that point, sources that are getting new PSD permits have to consider greenhouse gases. And also noted that a source can become a major source just because of its GHG emissions. So if it's not a major source because of criteria pollutants, it can still be triggered by PSD by virtue of its CO2 emissions. And this is pretty much based on the plain language of the Clean Air Act. There's no other way to get around it. That's difficult. So as I mentioned earlier, the major source thresholds under the PSD program are 100 tons per year if you are one of 28 listed source categories, or 250 tons per year if you're any other source. CO2 gets emitted in a much greater quantities than these other pollutants, and so if you apply that threshold, the number of PSD permits that would be required would go from 30 per year to 40,000 per year. For Title V, which is a 100 ton per year threshold, the number of sources that require a permit would go from 15,000 to 6 million. First of all, permitting authorities would be swamped. If I were a permitting authority, I would quit. Like, I'm not going to do this. It's too much work. And also, it's very expensive to get a PSD permit. It's not, sources like Pizza Hut and Dunkin' Donuts would be swept in by this rule, but to get a PSD permits, you have to hire lawyers, you have to hire engineers, you have to have relationships with the state permitting authorities, with EPA. It's a very long, expensive process, and the economy would essentially come to a halt if all these sources would have to get PSD permits. The EPA is like, all right, we're going to do something about this. And they relied on the three different doctrines. The absurd results doctrine. You know, come on, Congress didn't really intend for these sources to be regulated by the Federal Clean Air Act. The administrative necessity, we don't have the resources to permit all these sources. And the one step at a time approach, which is we'll regulate the biggest sources now and we'll eventually get down to the congressionally mandated smaller sources. Doctrines to establish what is the tailoring rule, known as the tailoring rule. And it's basically set out 4 different phases for the regulation of CO2 from new sources. The first phase is that any source that's going to emit 75,000 CO2 equivalent, or otherwise is subject to PSD, has to consider GHGs in its PSD permit. In other words, if it's going to get a PSD permit anyway, and it's going to emit above 75,000 tons CO2 equivalent, it needs to do a GHG backed analysis. And then phase 2, a source could trigger PSG just by their GHG emissions if they're above certain thresholds. In July of 2012, they kind of kept the status quo, and then by April 2016, they have to decide whether and how to regulate smaller sources. This has a lot of litigation risk. The statute is very clear of what a major source is. It is any source that is, as I mentioned, 100 tons per year if you're one of the 28 listed, or 250 tons per year. And so while it made a lot of sense, a lot of people thought that this rule might get vacated when it was challenged to the D.C. Circuit. And so the D.C. Circuit held oral arguments on all 4 of the rules we just talked about: the endangerment finding, the light-duty vehicle rule, the timing rule, and the tailing rule. I think it was last April. It held 2 days of back-to-back oral arguments. There was a lot going on, a lot of parties interested. It's very rare for D.C. Circuit to do something like that. And then in about a week after I did this lecture last year, the D.C. Circuit came down with its opinion. EPA went 4-0, undefeated. They're baseball players are batting 1,000. So the D.C. Circuit upheld each of these rules. And in December of 2012, it denied rehearing. There were 2 dissents from that. And there's one argument I think is interesting. I'll talk about that in a minute. And any number of petitions of cert have been filed by the parties, I guess around 25. And so we don't know yet whether or not the Supreme Court is going to accept cert. But so far, the regulation, all these rules have been upheld. So really quickly to kind of go through some of the arguments that were raised and rejected by the D.C. Circuit in this decision. So with respect to the endangerment finding, the petitioner challenged EPA's failure to consider public policy, the actual practical impact of regulating CO2. The D.C. Circuit pretty easily disposed of that. These are health-based standards. It only has to consider science when it makes these endangerment findings, so that was not an error. It also made a few other challenges. It said that EPA shouldn't have relied on third-party studies, but it deferred to EPA scientific expertise in that regard to do so, as it often does. The tailpipe rule, there weren't really any substantive challenges to the standards, but instead, there's this provision, section 202A2, which says that anytime EPA establishes a new regulation under Title II, it has to consider the cost to the motor vehicle industry. What the petitioners argued is, well, not only do you have to consider it to the motor vehicle industry, you should have considered the fact that by regulating under Title II, you can have to require regulation of stationary sources under the PSD program with all sorts of costs, and that EPA was arbitrary and capricious in failing to consider those costs. And the court said, no, very clearly they only have to consider costs from the motor vehicle industry. And so they upheld the tailpipe rule. So the timing and tailoring rule. Of course, the petitioners challenged this conclusion that by regulating CO2 under Title II, you now automatically have to regulate greenhouse gases under the PSD program. And D.C. Circuit, of course, disagreed and said that the statute unambiguously requires regulation because it applies to any air pollutant that is subject to regulation under the Act. So I mentioned the dissents to the rehearing. One of the arguments that was raised in the hearings was that, well, no, the PSD program is only intended to apply to criteria pollutants. And they used the statute language and show that if you interpret it the way that EPA did, some of the language was meaningless, and tried to get the court to decline to regulate CSD under the PSD program because it only was to criteria pollutants. The court rejected it, but in dissent, Judge Kavanaugh, who's the one that made the same snarky remark about EPA land and acronyms, he actually adopted that argument, and he agreed with them that the PSD program is only intended to apply to criteria pollutants. Therefore, regulation of greenhouse gases under that program is not appropriate. If this gets up to the Supreme Court, which is anybody's guess whether or not it will, I could see Justice Scalia or maybe some justices kind of grabbing that argument and running with it, which would then be a basis to do away with all this regulation of stationary sources under Title I. So the tailoring rule, the merits, D.C. Circuit didn't even get to the merits of the tailoring rule. And as I mentioned previously, there were a lot of litigation risk with it, so that's a big deal. And what they did was they dismissed the challenges on standing grounds. So there weren't any environmental groups that actually challenged it. It was only industry that challenged the tailoring rule. And to establish Article III standing, they said, well, if the court, having accepted and affirmed the endangerment finding, the tailpipe rule, and the timing rule, if the court were to strike down the tailoring rule, all these small sources would be subject to regulation, and Congress would have to do something about it. And they would come in and pass new legislation, and all our harms would be remedied. And the court said, no, that's too attenuated. We don't know if Congress would step in. Therefore, you don't have a sufficient harm that it can be remedied for Article III standing. So they took off their industry petitioner hat, they put on their environmental hat, and they said, it doesn't go far enough. The statute's plain. You have to regulate these small sources. And D.C. Circuit said, no, that's ridiculous. Like, look at your briefs. The whole time you're against this regulation. You can't just change arguments and positions for purposes of standing. You don't have standing. And so they dismissed the challenges to the tailoring rule. So any questions about this landmark decision, Coalition for Responsible Regulations v. EPA? Big win for EPA. and the environment. All right, so implications moving forward. So the D.C. Circuit has endorsed EPA's regulation of greenhouse gases, subject, of course, to Supreme Court review. The merits of the tailoring rule may never be challenged or may never be heard. I mean, the tailoring rule, as I mentioned, in 2016, EPA has to decide whether and how to regulate small sources, and so this rule, which had a significant amount of litigation risk, may never be, the merits of it may never be challenged. And so EPA might rely on this absurd results, administrative necessity, and these one-step-at-a-time arguments in future rulemakings because it worked for this one. And states that yet to adopt the GHG rules in their permitting programs, like Texas, now have less of a justification for doing so. And Madeline's case, we'll talk a little bit more about that, about why Texas is dragging their feet. All right, so we'll time to quickly talk about the greenhouse gas new source performance standards, as I mentioned earlier, which have been promulgated for EGUs, which is electric generating units. So in 2011, EPA entered into these two settlement agreements requiring them to issue these NSPSs for EGUs and refineries. They set specific deadlines by which they must do that. They have not met those deadlines. They're supposed to finalize them in 2012. They've only proposed one of them. But the one that they did propose is the EGU NSPS. And this came about in April of 2012. And so the proposal is an output-based emission standard of 1,000 pounds of CO2 per megawatt hour over a rolling 12-month period. This standard can only be met by the most efficient natural gas combined cycle technology. It cannot be met at all with a new coal-fired power plant, even if it has all the best control technology, unless it utilizes carbon capture and sequestration. And this rule applies to all fossil fuel burning EGUs. And so that's the big question of whether or not that's appropriate for EPA to do that. Now, EPA gave them a sort of an out, which basically said that after the 11th year of operation, if you install CCS, you can still be in compliance with the standards. But right now, we're not even sure if CCS is going to be viable in 11 years. So it's not very reassuring to new sources that want to construct a coal-fired power plant as to whether or not that would be sufficient. This is so controversial, this idea that you're going to promulgate a standard that cannot be met currently by a type of source, that the proposed rule was challenged to the D.C. Circuit, and they said, D.C. Circuit of course said, come on, it's a proposed rule, come back whenever it's finalized. But you can tell that there's going to be challenges to this, and for good reason, because NSPS has to be set on a demonstrated, I think I mentioned best demonstrated technology earlier, that's the NSPS standard, and so if this does get finalized in this current form, it will be subject to litigation. Under the statute, EPA has to finalize new NSPSs within 1 year. It missed that deadline in April. So it's anybody's guess, really, as to when EPA is going to finalize this rule and whether or not it's going to be similar as it is now. You know, one way they could do it is to have different NSPSs based on the fuel type. So an NSPS for natural gas combustion, and an NSPS for coal-fired, and that would ameliorate, I guess, the concerns of industry with this rule. But one really interesting aspect of the Clean Air Act is this little-used provision of 111D, which allows for the regulation of existing sources under limited circumstances. Basically, EPA is allowed to, and remember, all these programs we've been talking about, the new source performance standards and new source review, only applies to new sources. But you have these old sources that have been cooking along for 30 years, and they're really the primary contributor to pollution. So it'd be beneficial to regulate them. And under 111D, EPA can, because that allows them to regulate sources for which an NSPS is promulgated and there is no air quality criteria standards. It's not a NAAQS pollutant. Greenhouse gases meet both of those criteria. States play the primary role in this 111D arena. EPA will essentially give guidance to the states of how to go about reducing emissions from existing power plants. But if this rule is ever finalized, it'd be interesting to see how EPA implements its 111D authority. If you ask me, I think EPA kind of did it wrong. I think because there's not a lot of new coal-fired power plants that are being constructed right now, in large part because of the price of natural gas, but also because of the new standards. And all the CO2 emissions from coal-fired power plants are really coming from existing sources. But instead of just promulgating an NSPS that is suitable and not subject to so much challenge, and then going about regulating existing sources under 111D, they've promulgated this very controversial new source performance standard. So we'll see how it ends up. If anybody here works at EPA, you can kick that idea up the line. So in his inaugural address, his second inaugural address, and again in his State of the Union speech, President Obama said that he wants Congress to enact comprehensive climate change regulation. And if they don't, he's going to rely on his agencies to regulate greenhouse gases to the fullest extent of their current existing statutory ability. The question that stems from that is, well, what else could EPA do to regulate greenhouse gases? And there was a very interesting recent petition filed by the Institute for Policy Integrity, which has all different manner of requests for market-based regulation of GHGs, and it relies on very novel provisions, little used provisions of the Clean Air Act. For instance, Clean Air Act Section 115 applies to international air pollution. And this is actually a remnant of the pre-1970 amendments to the Clean Air Act. But it says that if you have the United States is contributing to human health and welfare endangerment in another country, and that country affords reciprocity to the United States, then EPA can require the states to do something about that source of emission. So theoretically, Canada applies reciprocity, and they're being impacted by greenhouse gas emissions just as much as anyone is, because when greenhouse gases are emitted to the atmosphere, they're in the same concentration throughout the entire atmosphere. So EPA could rely on 115 to regulate GHG emissions from existing sources in the states, but I don't think anyone's holding their breath for EPA to grant this petition, but it shows you some authority that EPA could rely upon. In addition, Section 615, which regulates pollutants that affect the stratosphere in a way that endangers the public. But two other additional requests they make, sort of, if you're not going to regulate under 115 or 615, you should consider ones that are more practical and likely to happen, is they request that EPA issue new source performance standards for other GHG emitting units like landfills, natural gas petroleum systems, agriculture, and coal mines. And so EPA may do that once it gets around to its NSPS for EGUs, and then refineries, it may start regulating sources as well. And it also asks for increased regulation under Title II. So we already regulate light-duty vehicles, heavy-duty trucks. It asks for regulation of motorcycles and the trailers of heavy-duty trucks. All right, so that's greenhouse gases. Before I turn it over to Madeline, let's talk about the case that she's going to discuss. Do you have any questions about GHG rules? All right, I'll turn it over.
Okay. Thanks. So Ryan, having given you a thorough education on the Clean Air Act as a whole, I'm going to talk a little bit about where the rubber hits the road, which is basically Congress enacts all these fun provisions and then says, okay, our job is done. EPA, you get to make it work. And so the cases I dealt with had to do with how EPA tried to do that for greenhouse gases. And as Ryan explained, get to my slide here. There we go. The most immediate problem that EPA confronted was this immediate applicability of greenhouse gas requirements under the PSD provisions. And as Ryan explained, that requires any major emitting facility before construction begins to get a permit that, among other things, implements BAT for that facility for pollutants, including greenhouse gases. So greenhouse gases come in at 2 points, whether you're a major emitting facility at all, and then whether you have to implement BAT for greenhouse gas emissions. And in this case, EPA looked at the language of the relevant provisions and said, we don't think we have a choice here. We have to do this. Section 165, which is sort of the centerpiece of the PSD provisions, says that a major emitting facility has to get a PSD permit. That, and then subprovision 4 says that has to apply back to any pollutant subject to regulation. As of January 2nd, 2011, greenhouse gases were subject to regulation under the vehicle rule. And then the definition of major emitting facility itself includes the stationary source of, quote, any air pollutant, which EPA has in fact narrowed to mean any air pollutant that's actually regulated under the Clean Air Act. But as of 2011, that included greenhouse gases. So in light of this reading of the plain language, EPA said, okay, as of January 2nd, 2011, any major emitting facility of greenhouse gases is going to need a PSD permit. So for a lot of facilities, that's fine if you're in a state where you can get a permit that works. So here is where we run into the fact that the PSD permit provisions are not the only part of the Clean Air Act. As we talked about before, the major sort of underlying structure of the Clean Air Act is this SIP aspect. And the SIP provisions were, in their modern form, enacted in the sort of first round of Clean Air Act enactment in 1970. The PSD provisions were added in 1977. They, it turns out, don't fit together entirely perfectly. And the reason you see this with greenhouse gases is because this was a sort of new phenomenon of a pollutant subject to regulation that was not a criteria pollutant. There's no NAAQS, and it's not a hazardous air pollutant, which is sort of the other big category. It doesn't fit in a neat little box for which Congress has said this is how you're going to deal with it. So instead, you have a pollutant subject to regulation, and your permit has to cover it, but the states with SIPs don't always cover it already. And there is a whole SIP revision process that you would have to go through in order to extend your SIP to cover greenhouse gases. Now, this wasn't a problem for every state because some states sort of had either looked ahead or were just lucky, and their way their SIPs work is it automatically applies to any air pollutant that EPA says is regulated. So essentially it's an automatically updating SIP, and the state just has to figure out the mechanics of applying that to PSD major facilities now. But there were 13 states where either the SIP said our PSD permitting applies to list of X pollutants, which didn't at the time include greenhouse gases, or which independently had some state law in the books or some other authority that said, state, you cannot regulate greenhouse gas emissions. In those states, the state can't issue a PSD permit that covers greenhouse gases. EPA can't issue a permit unless there's a federal implementation plan in place. So essentially, you have a de facto gap in permitting authority for those states as of January 2011, where if you want to build a source that's going to emit past threshold levels of greenhouse gases, there's no one who can give you a permit to construct that source. That's a problem. So what EPA did is essentially create a way in which it could cooperate with the states to figure out either whether the state could deal with this problem on its own or basically enable EPA to issue a federal implementation plan so they could step in and fill that gap in permitting authority. And EPA used Section 110K5 of the Clean Air Act, which essentially provides that if a SIP that is in place, it turns out is substantially inadequate to implement the requirements of the Clean Air Act, EPA can tell a state you have to revise that SIP. So EPA issued a SIP call, as call for revision, for these 13 states and said, your plan is substantially inadequate because there's a new pollutant subject to regulation, you don't cover it, you can't issue the necessary PSD permits that are required under the Clean Air Act. Now, so EPA issued that in September 2010, but the problem is that in itself does not give EPA authority to issue PSD permits. That was the first step in the process, which, as I remember, has to be completed by January 2011, so the clock is ticking here. And so under 110K5, EPA can give states up to 18 months to accomplish the SIP revision, but it's within EPA's discretion to set a lower or a shorter deadline, rather. And in this case, EPA said, okay, well, let's set a really short deadline because if they don't meet that, there's a failure to submit a required SIP revision. EPA then has authority under the statute to issue a FIP and start doing permitting. Now, EPA wanted to do this in as friendly a way as possible, and also not to do it unnecessarily. So there was sort of a process of dialogue with the states in the course of this rulemaking. Some states, it turned out, don't have a lot of PSD, major emitting facilities that need to get permitted. So they said, we're not in a rush. If we don't have authority to issue these permits in January, that's fine. Just leave us alone and we'll revise our SIP in time to deal with any permitting that needs to happen. So some got dealt with that way. Some states said, yes, this is an issue. We need someone to be able to permit. So those states sort of agreed with EPA that it would be fine if EPA set a deadline of December 22nd, I think, now I'm forgetting exact dates, but December 22nd, 2010, for them to submit their SIP revision, which is about, it was basically several weeks, which is not, if you have any familiarity with the SIP revision process, not going to happen. So it's essentially saying, we agree that we will fail to submit and you will give us a FIP, and that will fill this gap. So that was sort of the most of the rest of the states. And for those states, things sort of worked as planned. They failed to submit. EPA had its FIP waiting in the wings and issued that at the end of December 2010, and as of January 2011, they were all set. So then Texas was the one state for which that didn't work, which we'll talk about in a minute. For all the other states, things went well, but not everyone was happy with the idea that you would have to start doing the permitting as of January 2011. At this point, they were still litigating the CRR cases and sort of hoping this will all go away because EPA won't regulate greenhouse gases anymore. But this other EPA action basically gave them another lever to try to challenge when and how they would have to regulate greenhouse gases. So 2 states, Texas and Wyoming, and several industry groups came in and said, challenged the SIP call and sort of the associated failure to submit findings and issuance of the FIP, and said, EPA, this is all well and good that you're regulating greenhouse gases now. We'll deal with that in that other case. But under the Clean Air Act, under this cooperative federalism structure that Congress has enacted, you can't just go FIP us. We are supposed to be able to do this through a SIP. And so they argued basically that there was a regulatory aspect too, which is sort of less interesting, but they basically argued that sort of Section 110 and the SIP structure should trump the PSD provisions. The PSD provisions may say you need this permit, but in fact the states and industry said if there's a SIP in place that's been approved by EPA, that SIP applies, and as long as you can get your permit under that SIP, whether or not it covers greenhouse gases, you should be able to build. And unless and until that SIP is revised, let's just ignore what's going on with regulation of greenhouse gases. And in conjunction with that, they also said, and the states get 3 years to do the SIP revision. You can't tell us we have to do it in 3 weeks. That's a complicated process. It takes time. And based on various parts of the Clean Air Act and EPA regulations, you in fact cannot make us lift a single finger to deal with this until January 2013. So go away, please. Nope. Now we have skipped ahead. I'm not very good at this, apparently.
It's very sensitive.
Yes. Okay. Here we are. So getting back to Texas, Texas did not agree to the short deadline. EPA had not necessarily anticipated this, but had said, if you don't agree to the short deadline, we'll put in a default deadline of a year down the line, so December 2011, which is sort of actually a reasonable amount of time to accomplish a SIP revision. So the outcome of the SIP call for Texas was their PSD permitting provisions of their SIP don't cover greenhouse gases. EPA has no authority to issue permits in Texas at this point in time. And there's basically sort of nothing scheduled to happen in Texas until a year down the line. So you have a year when there's going to be no PSD permitting authority in Texas, which you have to understand is the location of about a quarter of the nation's PSD major emitting facilities. So it's not like you can just kick back and ignore this problem. You may also remember that at this time the economy wasn't necessarily doing so well. And so people were concerned about sort of stopping lots of construction projects at this point in time. So again, EPA says, well, what can we do to make this work? The friendly approach has not gone over so well. Texas is insisting you can't regulate greenhouse gases. You can't make us regulate greenhouse gases. Gosh darn it. So EPA turned to another provision of Section 110, which is Section 110 Case 6, which says that whenever EPA determines that its original approval of a SIP was in error, EPA can go back and basically, if it wants to, revisit that SIP approval. So that does not basically involve the state. The provision says it doesn't require any further submission from the state, so it's something EPA can do on its own. So EPA said, okay, Texas, we approved your SIP as to PSDs in 1992, so 20 years before all of this happened. But, you know, everyone knew at the time that the Clean Air Act said you have to regulate any air pollutant. Texas's SIP, as it turns out, is in the category I described where it just says a discrete list of air pollutants that they're going to regulate. So EPA says, well, we approved that, but we never dealt with the issue of what would happen if there was a new air pollutant that became subject to regulation, and that the PSD provisions were the same at that time, so the PSD requirements would be immediately applicable, and no one ever really thought about what you would do to permit sources during that time. So we were dumb. That was a mistake. We're going back, and instead of approving your SIP as we did in 1992, we're going to say it's approved to the extent it covers air pollutants, but we're issuing a partial disapproval to the extent it fails to cover new pollutants or provide any mechanism for you to do so, and that gives us the authority to issue a FIP. So all this happened between there were indications that there would be problems in like fall of 2010, and then on December 30th, EPA issued what's called the error correction rule in time so that they would have permitting authority as of January 2011. Now, Texas was also not happy with this particular approach to things, and so they sued and basically made a bunch of arguments saying that this is outside EPA's authority to do. It's a misuse of this provision. Among other things, the fact that this had been an approved SIP for 20 years, that there should be some sort of time limitation, that you can't go back and just change your mind about a SIP this far down the road. And then the sort of major argument was that this is way outside the bounds of what Congress ever contemplated this would be for. This is for, you know, you had a typo in the SIP approval, or there was some like math error when you were calculating some aspect of your attainment demonstration, something like that. This was not meant to accomplish basically a wholesale change in policy as to how the Clean Air Act is implemented, including regulating a whole new pollutant. Well, that's my last slide. That's because we don't know what happened yet. This was argued before the DC Circuit in May, so hopefully they will decide it sometime soon. As it turns out, it's probably in the shadow of the question of whether the Supreme Court will grant cert on the Coalition for Responsible Regulation. But I like to think of it as this sort of like, no one cares about it so much, but if it didn't happen, then the Clean Air Act wouldn't work so well. So hopefully speaking with my DOJ hat on, hopefully everything will be upheld and things can continue to go along as they have been. As of 2011, either states or EPA are doing PSD permitting in every state, and people have varying levels of happiness with that permitting process, as I understand it, but it's happening.
Takes a long time.
So the Clean Air Act is, for now, working. So that's it. And so we have about 10 minutes left for questions about those cases or anything else that we've talked about today.
If that gets overruled in this case that you just talked about, what exactly is the remedy for Texas?
Okay. Should I repeat that? Okay. So the question was, if, basically what happens, depending on how the court decides the case. So, basically, as you seem to have gotten the idea that this is an important question, Texas and the industry groups in Wyoming were essentially arguing for delay. And they have failed to accomplish that because it's 3 years later, pretty much. And they didn't win yet. So it's possible they could win and sort of have it be, well, great, good for you, pat on the head. So this was, in fact, a topic of discussion and oral argument. And as I think an open question, I will say one sort of practical aspect of it is what happens with the PSD permits that have been issued in the 3 years since this went on, particularly in Texas. Because if you invalidate the error correction rule and the FIP that was issued as part of that, then it raises the question of whether the permits that EPA issued under that authority, what happens to them. And so if we get to that point, that's a question EPA will have to answer. Just not to say I know the answer to that. But it is a little bit of, I think, an example of how litigation is only as good as the speed with which you can accomplish it. So we're not quite at the point of total mootness, but they can get sort of a principled victory at this point. Other questions?